Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast 102. We've got 3 cases this week, of course. There are 2 in the EAT and 1 in the ECJ. The EAT cases look at the early conciliation process and whether or not a claim for constructive dismissal had to be rejected because the early conciliation certificate had been issued before the constructive dismissal claim actually arose. There's then a separate EAT case on service provision changes and who the client is under the TUPE legislation. And finally, an ECJ decision which is another case on accrued but untaken annual leave. Finally, as a reward for sticking with me to the end, some thoughts on a really good podcast series which has been running for a little while but which I've only just caught up with. As usual, don't forget you can access the podcast via iTunes, on the Mayor Brown Internet or YouTube, and the Twitter feed, Nicholas Robertson at NicholasRobber11. It's also where we post out links to all the cases discussed. Please don't forget to check out the special podcast, Things I've Learned from Doing the Podcast, which is the companion piece to episode 100. And we've also done a not at all serious video, which is up on YouTube. Neither qualifies for CPD points, neither has any likelihood of increasing the chances of you receiving a Mayor Brown training contract. Just saying. So, on to business. First case, Compass Group UK and Ireland Limited and Morgan. This case, it's an important one dealing with the early conciliation process for a claimant with a claim for unfair constructive dismissal, where the early conciliation certificate was issued before the employee resigned for constructive dismissal. Let me explain how the situation arose, and let me also say, right at the start, I think this is a very common situation, and indeed, we've got at least one of these cases at the moment, so it's very much front and centre for us. The claimant was transferred into employment with Compass Group under a TUPE transfer. And I should say all of the facts in this case, because this arose at a preliminary stage, no facts have actually been determined at this stage. So it's a summary of the matters given in the EAT judgment. The claimant apparently said in September 2012 she had an acute anxiety disorder. She submitted a grievance about work matters 13th of October and instructed solicitors in November. This is going on in 2014. On 14th November 2014, she contacted ACAS for the purpose of early conciliation. A certificate of completion of the early conciliation process was issued 3rd January 2015. 2 months later, 18th March 2015, she resigned and claimed constructive dismissal, lodges a tribunal claim on the 20th of March claiming constructive unfair dismissal. So the point was that, factually, the ACAS early conciliation certificate could not have dealt with a constructive unfair dismissal claim, because that claim had not arisen at that point. It was common ground. The claimant had not gone through a separate early conciliation process between claiming constructive dismissal and lodging her forms with the Employment Tribunal. The issue for the AT was whether the fact that the ACAS certificate was issued in January 2015 meant that the constructive unfair dismissal claim in March 2015 had to be rejected on jurisdictional grounds. In order to understand the answer, it's probably best to go back and look at the rules themselves. Under the Employment Tribunals Act 1996, Section 18A, before a prospective claimant can present an application to institute relevant proceedings, quote, relating to any matter, unquote, the prospective claimant must provide certain prescribed information to ACAS about that matter, quote unquote. I'll explain why I'm referencing the words matter in a second. Thereafter, as we all know, the ACAS process is very, very light touch. There is an opportunity for the claimant to engage with ACAS and seek ACAS's help in any settlement. However, if either the claimant or the respondent doesn't want to have any discussions, there's no sanction, there's no compulsion on them. As the AT said in this decision, after the initial obligation to contact ACAS, the entire process is voluntary. Here, the respondent argued that there should be what is called a chronological approach to the construction of the early conciliation legislation. The claimant should not be able to include in their tribunal claim any cause of action that had not arisen at the date of notification to ACAS, because it could not have been notified to ACAS by definition. The Employment Tribunal, however, rejected the respondent's arguments. The case went up to the AT, and the EAT also rejected the respondent's argument. Their argument was the early conciliation, the respondent's argument, I should say, was that the early conciliation legislation should be construed in a way which implements its purpose, which is to facilitate the early resolution of disputes. The respondent claimed that the early conciliation process and certificate could only apply in relation to events and allegations which were before the issue of the ACAS certificate. Otherwise, that would defeat the purpose of the legislation. The EAT rejected this. First, they pointed out the legislation required a disclosure to ACAS of prescribed information about, quote-unquote, the matter. It did not require disclosure about a cause of action or a claim. It would be very easy for Parliament to have used that terminology. Instead, if they'd wanted causes of action, for example, to be disclosed to ACAS before going ahead. However, because the legislation refers to the word matter, that's broad and could include the beginning stages of a matter, even if that matter has not yet reached culmination, i.e. in this case, constructive dismissal. Secondly, since the ACAS process is entirely voluntary, there's no requirement to even provide any significant details of a claim. Basically, the names and addresses of the claimant and respondent are pretty much the essential minimum. As the EAT commented in one of the earlier cases in this area, the earlier conciliation process is a, quote, structured opportunity for parties to take advantage of ACAS conciliation if they choose to do so, unquote. And this case takes very much the same approach. In this context, the EAT said it's very easy to envisage a situation in which an individual contacts ACAS because there's an employment relationship that is deteriorating. At that stage, the individual might be certain he or she was going to be dismissed, or might have no expectation of that at all. The EAT did not see a difference between those cases when it came to bringing a claim. The underlying deteriorating employment situation based on, for example, bullying or discrimination, would constitute the matter between the parties whose names had been notified to ACAS in this hypothetical example. So, if the early conciliation certificate in this example was issued at a time when the relationship was breaking down but had not ended, that certificate would cover the claim for its eventual breakdown. The EAT did caution there's no free pass to bring claims about unrelated matters. However, they thought this could be determined by the good common sense of the tribunals and whether individuals are bringing proceedings relating to a matter in respect of which ACAS has been provided with information. Here, in this case, the matters complained of were all related to the implied duty of mutual trust and confidence, which should form part of the matters notified to ACAS. In addition, there was a complaint about failing to deal with a grievance that led to a constructive dismissal claim. Only these two last matters didn't predate the institution of the early conciliation process. So the EAT upheld the tribunal judge's view that there was a connection between the factual matters complained about in the claim forms and the matters that were in dispute at the time of the early conciliation process. In short, respondents' arguments were rejected. Well, I think this is an important case. I think many respondents would probably share this respondent's views. The constructive dismissal claim here was the major claim, and certainly would be the one where the majority of damages would be awarded if the claimant won her case. You can certainly understand the respondent's view that for the entire constructive unfair dismissal claim never to be mentioned to ACAS seems to drive a coach and horses through the legislation. If the constructive dismissal claim does not require separate early conciliation, then it's very difficult for a respondent to knock back a claim for constructive dismissal on the grounds that there should have been separate conciliation process. In this case, it would have been impossible, of course, for that constructive dismissal claim to be raised with ACAS because it arose after the certificate had been issued. Nonetheless, I think it's quite clear what approach the EAT is taking, unless there are truly different matters affecting the employee before and after the early conciliation certificate is issued. This decision of the EAT is unlikely to encourage employment tribunals to take a tough approach. It's only going to be in the clearest of cases, and personally I suspect where the evidence is in writing as to what the employee was complaining about before and after the early certificate is issued, that there will be a prospect of showing that there is a jurisdictional bar in relation to later matters, unless the employee goes through the separate conciliation process. So, that's the case of Compass Group UK and Ireland Limited and Morgan. Next up, CT Plus, Yorkshire CIC, and Black and others. This is another EAT case, and this one involves service provision changes. The background was that CT Plus was a community interest company owned by a charity. It had run a park and ride service at a car park owned by the local council on the outskirts of Hull. It had started its operating contract in 2010 and this had run until 2013. Stagecoach is, of course, a large commercial operator, and they too had an operation in the area. The council ran a re-tender process in 2013. Stagecoach applied. The re-tender process got delayed, and Stagecoach decided it could run the service commercially without waiting for the re-tender to complete. CT had been receiving a subsidy from the council, in return for which the council had significant controls around things like timetabling, types of buses to be used, branding, logo, and so on. There was also a share of fee revenue for the council if the fees exceeded a particular level. Apparently by law, if a commercial operator wants to operate on the same bus route as a subsidised operator, the subsidy to the subsidised operator needs to cease. So when Stagecoach notified the council it was going to start running a commercial service from the same park and ride car park, the local authority had to give notice to CT Plus that it would be stopping their subsidy at the same time. This led to CT Plus ceasing its operations when the subsidy ended, which was at the same point as Stagecoach started running a park and ride service from the car park. When Stagecoach started running the service, 29th September 2013, it took no assets directly from CT. There was no contract between Stagecoach and the council. There was no subsidy. Stagecoach changed the timetable for services outside peak hours, despite the local council misgivings, and recruited 70 drivers predominantly through internal transfers. The employees of CT Plus were all made redundant. They asserted there'd been a TUPE transfer under the service provision change rules to Stagecoach. They also sued CT Plus as a backup. Now, if you remember, there's a service provision change if activities cease to be carried out by a person, the client, on its own behalf, and are carried out by someone else on the client's behalf, or activities cease to be carried out by contractor 1 on the client's behalf and are carried out by contractor 2, or the activities cease to be carried out by a contractor on the client's behalf and are instead carried out by the client on its own behalf. Outsourcing, second generation outsourcing, insourcing. The employment judge here decided that all the features of a service provision change were present, apart from one. The judge decided that Stagecoach was running a commercial operation for itself, therefore there was no common client before and after the alleged transfer. Here, therefore, the focus to establish whether or not there had been a service provision change was on the identity of the client before and after the transfer. The Employment Tribunal said that when CT Plus was providing the services, the council was the client for the business. It was receiving the benefit of the services, fee-sharing arrangement, and had a significant control of the operation. The employment judge, however, described the council as merely being, quote, an interested bystander, unquote, after the 29th of September 2013, when Stagecoach were running the service. The council no longer had the same degree of influence and control they previously had, when as client they could have directed the frequency of services and refused alterations to the service. The Employment Tribunal judge accordingly found that Stagecoach acted on its own behalf, so it had no client for whom it was acting. It was a purely commercial transaction. There simply was no client anymore. The EAT, in essence, accepted that the tribunal judge was entitled to come to the decision which he'd reached. He'd not taken an unduly legalistic or narrow view of the legislation. His view was certainly not perverse. The appeal attempted to argue that the local council remained the client even when Stagecoach was running the service, but factually that was always going to be a very difficult argument to make. The case is maybe an unusual one on these particular facts. This was a subsidised operation providing bus services which were replaced with a commercial operation providing the same sort of bus services. You might ask how often these sort of facts will come up. However, I wonder, it's not that big a stretch to see that someone buying a business might turn down part of that business on the grounds that they'll set up their own equivalent part after the main business has been bought. Imagine a company which is a small department responsible for testing bits of the kit. If the purchaser decides it doesn't want to take over the testing department, but wants to set up its own testing department, is that such a big factual step on from this case? The other point to flag up is that it doesn't appear to have been argued that there was an ordinary TUPE transfer. This could well have been a very difficult argument if Stagecoach didn't take over any assets from CT Plus. Equally, it may have been argued first time round and didn't feature in the appeal. But given that it's difficult to disagree with the tribunal judge's decision that after the transaction Stagecoach had no external client, and obviously in passing it could not have been the client before the transaction because it had nothing to do with the service whatsoever. So it does appear that a future case might choose to focus on whether or not there was a sufficient transfer of assets in the form of transfer of passengers, end users, goodwill, right to use the car park, etc., so as to have an ordinary TUPE transfer rather than a service provision change. In passing, I'd add, it's amazing how often, in my opinion, when analysing a situation, parties choose over choose to pass over whether or not there was an ordinary duty transfer and go straight to service provision changes. I'm not suggesting for a second that's what happened here, but as a general comment, and I've sat in plenty of meetings where people have assumed it's a service provision change or nothing at all. Of course, fundamentally the starting point should always be whether there's an ordinary duty transfer on the Speicher's multifactorial test. So that's the case of CT Plus, Yorkshire, CIC and Black and others. So third and final case, Maschek, M-A-S-C-H-E-K, and something unpronounceable, Magistratsdirektion, or words to that effect. So this is a decision of the European Court dealing with accrued but untaken annual leave. The Working Time Directive, of course, gives workers the right to paid annual leave of at least 4 weeks. That minimum period of annual leave cannot be bought out unless the employment relationship is terminated. In Austria, this has been translated as providing that you do not pay out accrued but untaken annual leave if the individual is retiring at his or her own request. Mr. Maschek didn't go to work from 2010. He ended up effectively on garden leave through until July 2012. He claimed that he was entitled to paid annual leave. Just to complicate matters, he also fell in June 2012, i.e. a month or so before his eventual departure date. The European Court decided it was not permissible to have the Austrian legislation remove the right to accrued but untaken holiday leave from individuals who were retiring at their own request. There's nothing in the directive to say that where an employee is choosing to leave employment, they would necessarily forfeit any accrued but untaken holiday. Secondly, the right to paid annual leave has a particular purpose. It's to enable a worker to rest from carrying out work, to enjoy a period of relaxation and leisure. Therefore, generally, where an employee has agreed to stay away from work whilst being on full pay, the employee will be able to use up holiday in that period. Therefore, the employee would not be entitled to be paid accrued but untaken holiday at the end of that period, unless there was a particular reason, such as illness, by which the individual meant the individual was unable to use holiday. This is part of an ongoing series of cases which reiterate that individuals who have accrued but untaken holiday leave are able and indeed entitled to cash it in when they leave. There's a separate strand of cases which indicate that where individuals are prevented from taking accrued holiday because they're ill, this needs to be carried into the following holiday year. There's some suggestion that in England, of course, where the working time regs permit a payout on accrued but untaken holiday at the point of departure, but forbid any attempt to pay out holiday or carry holiday into the following year. That holiday could not be carried forward for more than 18 months. That's the Plum and Duncan Print Group case, which we covered in an earlier podcast. Here, however, I think the point for employers in this case is that if an employee is put on garden leave and is not required to report into the office on a regular basis, then it may be implicit in the arrangement that the employee is unable to assert subsequently that they were prevented from taking statutory holiday during that garden leave period. Therefore, the employee's holiday entitlement could be reduced or forfeited if the employee elects not to take holiday in that period and tries to cash it out at the far end when employment actually ends. I'm not sure whether HR will necessarily want to take up this opportunity to avoid payments for accrued but untaken holiday. Our experience is that many HR people feel it is right and proper to allow an individual to bank holidays and then to be paid out those holidays on top of any other severance payments. Equally, if we're talking about a day or two's holiday leave, it may be very uncommercial to try and remove that from an employee on departure, particularly if the employee and the employer may well come across each other again, perhaps where the individual's going off to a client or a supplier or something, and it's best not to send them off across with the employer. So I think the case should primarily be seen as offering an opportunity for employers rather than setting up an invariable practice. It does also mean that employers need to be quite careful either about custom and practice of paying out accrued holiday pay, or more particularly about what they say to an employee when they are sent on garden leave. Obviously, it'd be much wiser to indicate to an employee they're expected to take the holiday, if that's the case, when they're sent on garden leave. But equally, if you have a very restrictive garden leave approach, which requires the employee to be continuously available to answer work queries, etc., and I've seen a couple of these clauses, then I think that would cut right across the idea the employee could just take holiday in that period. Obviously, of course, if you say the employee is going to be entitled to take accrued but untaken holiday at the end of employment, that may well be construed as carrying the implication the employee does not need to use that holiday up any sooner than that if they don't want to. So that's the Maschek case, and I'm not making the mistake of pronouncing the full name again. So, thank you very much for listening to podcast number 102, Onwards and Upwards. We're in the foothills of the next 100. I said I'd say just a few words about my new podcast discovery. There's no such thing as a fish. This is done by the people who do the research for the QI series, and in essence, there are 4 of them, and the thing is that each of them has to come to the podcast each week with a new fact that they've learnt, and they're wonderfully arcane and miscellaneous facts. So in one of them, I remember it's that some Dutch trains are fitted with lasers to clear the leaves on the tracks. In another one came up with the fact that President James Garfield, who was shot and died a couple of months later in the US, he was looked after. His chief physician was someone whose first name was Doctor, so he was Dr. Smith, or whatever his surname was. I'm sure we can all agree that the world is a better place for knowing these and other arcane facts. And like all the best sort of group chat podcasts, it sounds like a great dinner party conversation that you'd love to be part of. So do give it a go. No such thing as a fish. Don't stop listening to this podcast, of course, but I'm sure we've all got room in our lives for one more podcast. Okay, so thanks very much for listening. Stay safe, and I'll look forward to speaking again on podcast 103, whatever that may bring. Bye.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email Nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.